Let's have a closer look at some of the features of the adversarial system, and I'll just quickly go through these because I presume that you're fairly familiar with them. It's the system that's used in most common law countries in civil and criminal cases. The parties define the issues and the parties determine what evidence is to be adduced. So in a criminal prosecution brought by the police, they have to prove beyond reasonable doubt that a person committed an offence. They will be working out which witnesses they want to call. In a civil case where a plaintiff is bringing a claim for negligence or breach of contract, it's the onus of proof on the plaintiff to prove on the balance of probabilities that there's been negligence or the contract has been breached. The court proceedings are usually fairly formal, and the judicial decision maker, that's the judge or the magistrate, is bound by the rules of evidence. So it's not a search for the truth of what happened, and it's always very concerning when you're sitting as a magistrate and someone's into court, it comes into court and says they're after justice. That rings alarm bells, because in the adversarial system you can see it's the parties who are defining the issues. The judge or magistrate makes decisions based on the adversarial evidence presented to them, and the decision maker doesn't play any role in terms of saying to the parties, you really should be getting a statement from this person, or have you thought about calling this evidence? Now, just before I move on to the coroner as inquisitor, I thought I just might ask you to turn your mind to other inquisitorial processes that are outside of the court system. And the government uses the inquisitorial process quite a lot. If you think about it, we have both federal and state royal commissions running at the moment. We have the Federal Royal Commission that is investigating institutional responses to allegations of child sexual abuse. And in Victoria, we have the recently announced Royal Commission that's looking into family violence. And so there's terms of reference for those Royal Commissioners, and the Royal Commissioner has power to call witnesses to give evidence to be examined in respect of that evidence. Similarly, you might be aware that the Commonwealth Parliament has parliamentary committees that are also inquiring about certain issues, and you'll be aware that the Finance Committee recently was looking into the tax that was paid by corporations and was able to get the CEOs of Google, Apple and Microsoft to come along and be questioned about their taxation structures. And another inquisitor we have on the scene in Victoria is the Ombudsman. The Ombudsman set up by an Act of Parliament to inquire about the administrative functions of authorities, and the Ombudsman can inquire either on a complaint or on its own motion. But if you look at some of the features of the coroner as inquisitor, the coroner is an active inquisitor. I've put there that it's a specialist court. I'll speak a little bit more about that later. The coroner generates the evidence and has coercive powers that are generally exercised by the police. I don't sort of break in somewhere and say, stop, give me this or that. So the coroners exercise, the police exercise those coercive powers on the coroner where the coroner believes something is reasonably necessary for their inquiry or their investigation. When an inquest is held, the coroner is the one who determines what the issues are and who the witnesses are to be called. And the coroner is not bound by the rules of evidence, but has to accord natural justice. The court proceedings are conducted with little formality. I always think that's a little bit of a misnomer, because you can have the nicest coroner in the world, but it's always within a court system which has a gravitas attached to it that can be quite disarming to people when they're not familiar with the court process. In any event, the rules of evidence don't apply, and there's a Court of Appeal case of Priest and Maxwell that's made comment in respect of the coroner's investigative function. Now, that was an inquest into the disappearance of Linda Stillwell, who was a 7-year-old child when she disappeared from St Kilda in 1968. And the coroner in that case refused to admit statements of similar fact evidence regarding the disappearance and death of other children. And in that case, the Court of Appeal said that the requirement of the coroner to make certain statutory findings requires the coroner to pursue all reasonable lines of inquiry. And so this is supported by the waiver of the rules of evidence, which ensures that a coroner has the power to conduct as broad as an investigation as is necessary.